Let's go to the story now. In a key case before the Pretoria High Court, retired judges Willie Seriti and Hendrick Musi will argue that they are not subjected to an investigation by the Judicial Conduct Committee for their role in the Seriti Commission. And remember, the Seriti Commission was looking into the arms deal saga. Of course, this is a matter that's been going on for quite some time. They're arguing even around who should be called a judge and who shouldn't be. Let's speak to Open Secrets lawyer Luthando Vilakazi. Luthando, thank you so much for your time this evening. I suppose part of, there's a lot of questions to answer here, but there's also this one, that will now need to be answered given what they are arguing, is that when is a judge not a judge?
Hi, thank you, Bongiwe, and thank you for having me. So the question that needed to be answered today in court is, at least from our position, one that has already been answered by the JSC Act. The JSC Act defines a judge to include retired judges, and that means that they are subject to all the sort of obligations and conduct and disciplinary processes under the JSC Act for their time whilst they were in active service as judges.
And I suppose, one of the things that, one really asks themselves is that this particular question comes, and the Act is very clear on, who is to be a judge and who is not to be a judge. But at the end of the day, this all boils down to the issue of accountability, particularly when you look at what has happened post the findings of the arms deal inquiry.
Yes, exactly. So, there's already been court cases that set aside the findings of that commission because of the serious lack of commitment to seeking answers, to holding people accountable, to questioning key witnesses, looking at key evidence. There were very many irregularities in the way the commission was conducted by Judges Seriti and Musi. And that is why Open Secrets laid complaints before the Judicial Services Commission to inquire and investigate that conduct. And that was the point at which Judges Seriti and Musi then raised whether or not they should even be subject to that process by challenging the constitutionality of the definition of a judge. But of course, the arms deal is also something that has a long shadow over our history. It is something that we cannot pretend does not continue to have relevance, considering how much capital was lost and how much was lost to corruption and bribery and fraud. And those are funds that could be used for much better things. Those are funds that could have been used towards fixing our energy crisis or our healthcare crisis or our employment crisis. So, pick whichever crisis you like. So it is really important because of that to continue to seek accountability where we can, and also to bolster and continue to have, we must have faith in our judiciary, and we can only do that if we know that our judges are held to a higher standard that judges should be held to.
And especially, Luthando, when you think about the fact that, right now, there is even, that court ruling that looks at the fact that some of the evidence was not even considered, and we still are none the wiser as to how also, those particular thousands of papers were missed. And now, what does the dragging of this matter up until a day like today mean for accountability or lack thereof?
I think, in all serious terms, it means that accountability isn't being given the importance that it should be. And considering how we are inundated with state capture crises, we've been grey-listed because of our lack of accountability measures that are effective and enforceable, it sort of says that we need now, as South Africans, to sort of decide that we are going to take accountability seriously and ensure that any measures that seek to address that are followed through, are being taken seriously, whichever branch of government that may be, and in this matter, the judiciary.
Especially because when you look at the fact that, you know, there's been, of course, varying responses to the findings of the Seriti Commission. A lot of people sometimes calling, you know, some people calling it a missed opportunity, other people saying that it didn't go far enough, other people saying that, you know, it really was a wasted opportunity, while other people are indifferent towards it. But when one then looks at all of this and this particular case and the complaint that, you know, of misconduct that your organization also lodged at some particular point, and now the investigation that needs to get underway. Let's talk about the precedents that this could set, particularly when you look at how commissions are set in this country. Sometimes we see some recommendations gathering dust.
Absolutely. Commissions of inquiry are a institution in South African, you know, judicial operations because of the fact that they allow for further accountability than maybe necessarily a court may have the powers to do, or maybe for whatever reason a commission of inquiry is just more important for purposes of accountability. I think that is clear by you know, the Life Esidimeni inquiry, the state capture inquiry. And I think it also, it means that we are no longer able to trust what it means when a judge says this is our finding, and then we have faith that they've done so in a way that, you know, holds true to their office. And I think you've also raised another point around what does it mean for South Africans to have faith in our judiciary? And if that is something that is eroded away at any point, it raises questions of the rule of law, it raises questions of judicial independence and integrity. And I really don't think at this stage in our political journey as a new democracy, we can afford to have a judiciary that can be questioned. And the unfortunate matter of, you know, the unfortunate result of this matter is that if Judges Seriti and Musi are successful in their application, the end result will be that any misconduct that a judge undertakes during their active service will no longer be able to be reviewed or investigated as soon as they decide to retire. And that creates a very dangerous loophole. It creates a very dangerous precedent, because it means that all it takes is a resignation letter, and you can then enjoy your remuneration package and pension that is handsomely paid for by South African taxpayers without ever being held accountable for any misconduct.
And that is the nub of, you know, the question there as to just how far does accountability go. But let's see then, you know, what becomes the outcome of this matter. Do appreciate your time, Luthando. It's a very important conversation that really must be had, especially when you look at how we still are talking about the Amstel saga. Even in the courts, it's still not a finalized matter. That was Luthando Vilakazi, and she is a lawyer for Open Secrets.